In Guyana, sexual offences continue to make up a substantial proportion of matters before Guyana's courts.
There are summary charges and there are indictable charges. The first, a summary charge, will be done in a magistrate's court, and the magistrate will have to determine if the person charged is guilty or not guilty after hearing all the evidence in the matter. Once the magistrate has made that determination, the matter will be completed in the magistrate's court. The second charge is an indictable charge. An indictable charge will begin in the magistrate's court, and the magistrate will have to determine whether there is sufficient evidence for the person charged to stand trial in the High Court. If the matter moves to the High Court, the matter will be heard by a judge and 12 jurors.
Guyana's Sexual Offences Act of 2010 outlines the law relating to sexual offences.
There are several sexual offences contained in the Sexual Offences Act, Chapter 8:03. Once the offence involves penetration, that offence is done on indictment in the High Court. The two common offences that involves penetration are rape and also rape of a child under 16. Rape is governed by Section 3 of the Sexual Offences Act, and the penalty for that is imprisonment for life. Rape of a child under 16 years old is governed by Section 10 of the Sexual Offences Act, and the penalty for that offence is also life imprisonment. The other two prevalent offences under this act are sexual activity with a child family member and sexual activity with a child under 16 years. In the High Court, the penalty for sexual activity with a child family member once there is penetration is imprisonment for life. When there is no penetration, it's imprisonment for 14 years. In the magistrate's court, the same offense committed where there is no penetration carries a penalty of imprisonment for 5 years and $1 million fine. With sexual activity of a child under 16 years, the matter may be heard either in the magistrate's court or in the High Court, depending on the circumstances of the offense. Where the matter is heard in the magistrate's court, the penalty for this offense is imprisonment for 5 years. Where it is conducted in the High Court, the penalty for this offense is imprisonment for 10 years.
The Sexual Offences Court is a specialized court established according to Section 44 of the Sexual Offences Act. It is located in the compound of the High Court of Guyana. UNICEF Guyana partnered with the local judiciary in establishing the Sexual Offences Court.
UNICEF was part of the sexual offense legislation's reform, and from there we also have supported the implementation, and one of the big important pieces is the Sexual Offences Court that has been established. And UNICEF supported the technology and means to have the court very friendly to children, in particular the youngest, when they have a screen to protect them if they don't wish to face their accused person, and also in particular having also their story already recorded. They don't have to say twice the same, and it can be very traumatized, or they can be very afraid of doing again. And that's where we bring the child-friendly environment to the Sexual Offences Court.
The court has a number of special features that allows survivors to give evidence about a most painful experience in an environment that is more encouraging for them to do so. One of these features is the use of technology as specified in Sections 53, 55, and 56 of the Act to protect the complainant, that is, the person who makes the legal complaint.
This is a special room that the complainant may choose to give evidence via audio-visual link by sitting in front of this computer screen and camera, and the testimony will be heard in the courtroom. The complainant may have a support person present while giving testimony.
Complainants may also testify by Skype no matter their location. As a result, the entire trial is recorded and typed transcripts are available, making it no longer necessary for judges to write evidence in longhand. The result is speedier trials. As far as possible, the court also ensures that the accused does not personally cross-examine the survivor. This means that the court must provide state-assigned counsel to the accused that cannot afford to retain their own lawyer. While the Sexual Offences Court seeks to make testifying less traumatic for the survivor, the person accused will receive a fair trial with due process in this special court. A trial of a case in the Sexual Offences Court does not mean automatic conviction. In addition, a judge will also tell the jury that sexual offences can take place among a variety of persons who display a wide range of responses, and that the absence of behavior that the jury may expect does not mean that an offence was not committed. There is no stereotype for who may be a victim or perpetrator of a sexual offence.
Persons charged with an offence under the Sexual Offences Act will not result in an automatic conviction. They should expect a fair trial where their constitutional rights are maintained. It is only after a trial that a jury will decide whether the accused is guilty or not.
Even though the Sexual Offences Court is in Georgetown, special measures such as screening is done at the high courts in Berbice and Essequibo as a temporary measure until the technology is rolled out in these courts. Through the Sexual Offences Court, survivors of sexual assault may tell their stories in a more supportive and comfortable environment.